Okay, we were dealing with the European Union and the origins of the EU. Last Tuesday, we started saying that the EU is the most successful integration process in the world. As we've stated, it started with the establishment of the 3 European communities, including the 3 European communities, including
European Atomic Energy
First, the European Coal and Steel Community. Second, the European Atomic Energy Community. And third, the European Economic Community. Therefore, when we say European communities as plural, we refer to these 3 communities which all had economic aims for integration. Then we dealt with the question whether these communities were the first attempts of integration in the European continent in the history, or were they previous attempts of integration? Yes?
No, because Napoleon Bonaparte, Hitler, the Catholic Church, and 2 others that I don't remember, they also tried to unite the Europe, and they weren't successful. I mean, partially, maybe they were successful, but it wasn't for good. It wasn't permanent, so they failed.
Exactly. We said long before the European Union, the establishment of the European communities, there were previous attempts of integration, including the attempts of certain military force, including the Roman Empire, the Ottoman Empire, the attempts of Napoleon, the attempts of Hitler, who wanted to integrate the European continent using force as a medium for integration. We have also mentioned that the attempts of Catholic Church may also be considered as other sources for integration, at this time using religion as a tool for integration. Then we spoke about certain philosophers, including Jean-Jacques Rousseau, Jeremy Bentham, Immanuel Kant, now using dogmas as a tool to integrate the European continent. Then we came to World War II. We spoke about the defeat of the superpowers by the World War II and certain attempts of integration again in the European continent after the World War II. We spoke about the Marshall Plan. We spoke about the establishment of OEEC. We spoke about the establishment of NATO, Council of Europe, etc., showing military, political, and economic attempts for integration. Then we spoke about the Schuman Plan of 1950, including the establishment of a supranational institution for integration on coal and steel. Then we spoke about the aims of Euratom and the EEC. And what was the aim of the EEC treaty then? The EEC treaty, the Treaty of Rome of 1957. Yes, Deniz?
It was to establish an internal market.
It was to establish an internal market, a common market between the member states where there exist no borders, no barriers. So what is provided is free movement of goods, services, capital, and workers. It also aimed for approximation of laws, economic policies of the member states to increase the standard of living in the member states as well. Today we will speak about the distinct characteristics of European integration. We said that the EU today, as we know it, is the most successful integration process in the world. But why is it so? What are the main reasons of success of the European communities then, now the European Union? And then we will move to the differences between the EU and other international organizations, because we do not call the EU as international. On the contrary, we call it supranational. Okay, now then, what are the main characteristics of the European integration that made it different than the previous attempts of integration? What do you say? Yes, Deniz?
You can say, for example, by example, Maastricht Treaty introduced EU citizenship. I mean, it's very different because we haven't started to use citizenship yet, but I mean, we can see citizenship above countries. I mean, above countries' citizenship in any international organization. So.
But here we should think about the previous attempts of integration. You should compare the European communities with previous attempts. When I say previous attempts, you understand?
The church.
Exactly. Why they failed and why the EU succeeded. There must be some reasons. Yes, Umut?
I think the main difference is that EU consists of economic integration, and it is the most powerful bonding.
Exactly. Here in the EU today, the tool for integration is economics. Therefore, in the EU, economy is used as a medium for integration, as a tool or as a medium. What do we mean with that? We mean that the member states of the EU are linked, connected to each other by the principles of economy. They share the same economic policies, and when you establish such links between the member states based on economics, it is very difficult to break it in the future. It is not easy. You create interdependence between the member states by using economy. Is that true? Yes, it is true. Therefore, the first reason of the success of the European Union is the tool. It is economy rather than force or dogmas or religion. What else? Yes, Atakan?
They came together through a treaty, not of, as you said, force or religious bonds.
So they wanted to...
Yes, they didn't force anyone else to join them.
Exactly.
It was with their own consent that they joined.
Bravo. This we call willingness of the member states. Willingness. This is one of the important characteristics of the European Union. The accession procedure in Turkish? No? Exactly. Katılım usulü. This is the procedure that is applied in the European Union to become a member state of the EU. It is provided in the founding treaties today. Article 49 of the EU treaty provides for the terms of accession, the conditions and the procedure of accession. Therefore, all the states know such conditions to become an EU member state. Again, in its establishment as well, the member states came together themselves to establish such European communities. Therefore, no force was used. There were no dogmas or no religion used to connect the member states, the founding members of the European Union. Therefore, this is the second characteristic of the success of the EU. There is one left. Yes?
And also we said that coal and steel are the raw materials for the heavy industry. And after the World War II, it was a huge mess in Europe. So I think that when they created the European Union or the other communities at first, they believed that it would be the way for disarmament. Not completely disarmament, but they would be able to trust each other so that there wouldn't be another world war.
Yes, this is one of the aims of the EU, to keep peace and prosperity in the European continent. But we look for now distinct characteristics that we, yes, Deniz?
Common policy, can you say? Common foreign policy.
Not common foreign policy. It is very disputable, the common foreign policy, as I will be explaining today, but a common legal system. This is one of the very important characteristics of EU. This is why we come together every other day with you. This is the reason why we are at the moment here. This is the establishment or development of a new legal system, a common legal system, which is applied in the territories of the member states. It is called as European Union law. Who develops this legal system? Who enacts, who develops the rules of this legal system, the European Union law? Yes, Atakan?
European Parliament.
So it is the EU institutions. Yes, it is true. In the European Union law, as you will be seeing later, there is the transfer of power. Transfer of power. In Turkish, yetki terki, technically. This means that in the areas which are provided in the founding treaties of the European Union, there is a transfer of power from the member states to the European Union. As you will be seeing later, in certain areas, this transfer of power is exclusive. Exclusive. In Turkish, sorry? No? Exclusive. Münhasır. Münhasır. This means that in these areas where the transfer of power is exclusive, that the EU has the power to adopt legally binding rules alone. If there is a transfer of power from the member states to the European Union, and if this transfer of power is exclusive, this means that only the EU can legislate in these areas as a principle. For these areas, we say that the transfer of power from the member states to the European Union is absolute and irrevocable. Absolute and irrevocable, mutlak ve geri dönülmez. It is absolute and irrevocable. Therefore, this means that in these areas, the member states can no longer adopt legally binding rules as a principle, and you will be seeing later that this has got two exceptions. But as a principle for now, we say that depending on this or based on this transfer of power from the member states, the EU shall adopt legally binding rules. Therefore, the EU includes the legislative organs, as you know, including the European Parliament and the Council as two legislative organs. They adopt legally binding rules. Who interprets these rules adopted by these two institutions? Who interprets the European Union law? The Court of Justice of the European Union. Yes, as the Court of the EU, the Court of Justice, interprets. It has got this monopoly to interpret the European Union law. Therefore, this common legal system is developed and interpreted by the EU institutions, as you know, and this is a sui generis legal system developed by the European Union. Sui generis in Turkish kendine özgü, nevi şahsına münhasır. Therefore, this legal system, as we know it, the European Union law, is distinct from national law and international law. It is a new legal system, independent from national law and international law. We will be speaking about autonomy of EU law, autonomy özerklik of European Union law to mean that it is an independent legal system than national law and international law. It has got distinct characteristics, as you will be seeing. Any questions? Okay. So we say that this is a new legal system, a supranational legal system, and the EU is a supranational organization rather than being international. So what are the differences that we should state when we compare the European Union with international organizations? What do you say? We have mentioned this at the very beginning of the semester. Yes, Atakan?
We said that we have a principle that EU always prevails. So in a dispute between a nation and EU, the decision of EU will always prevail. It is in a higher authority.
Okay, we spoke about the supremacy of EU law. It is true. Yes, we will come to that. Yes?
There is a difference about voting process.
The voting is different. How different is it?
Because in the EU, most of the times, with qualified majority, the decision is made.
Okay, in the EU, there is qualified majority voting. In the international organizations,
The consensus.
how do we say it?
I didn't remember.
Okay, then I will explain. That would be simple majority or unanimity. Unanimity. Okay. What else? Okay. One of the most important differences between the EU and international organizations, or one of the most important characteristics of the European Union, is its voting system. As we know, today, most of the legally binding instruments of EU law are adopted subject to qualified majority voting. In Turkish, qualified majority voting? Bravo, nitelikli oy çoğunluğu. To calculate the qualified majority voting, in very general terms, we will be explaining later, we need majority of number of member states, the majority of the member states, and majority of total population of the European Union. On the contrary, unanimity in Turkish, oy birliği, and simple majority, basit çoğunluk, are also used in the European Union law, however, in very limited cases. Therefore, today, the rule is qualified majority voting, which includes the majority of the number of member states and the majority of the total population of the European Union. Therefore, when an instrument is adopted subject to qualified majority, this means that it will be binding for all the member states of the European Union, including the ones who have given a negative vote on that proposal. Therefore, it shall be the instrument shall be binding for all the member states of the European Union. This is one of the most important characteristics of the EU. Secondly, as we have stated previously, the territorial area of application of EU law is the territories of the member states. Is that true? Yes, the EU law is applied in the territories of the member states. In the territories of the member states, there is also national law to be applied. So in the member states today, there are two laws to be applied. One, national law. Second, European Union law. We will be seeing later what happens when there is a conflict between them. We will be speaking about the conflict principles. But as we will be mentioning, one of the most important principles is that the EU law prevails. There is supranationality, supremacy of EU law or primacy of EU law, which means when there is a conflict between EU law and national law, the EU law shall be applied. This is not the case when there is a conflict between national law and international law at all times. Thirdly, as we stated previously, there is transfer of power in European Union law. And especially as far as the European Economic Community was concerned, this transfer of power was not limited to any area. You know what I mean? We spoke about this before. In the coal and steel community, we said the aim of integration was restricted to coal and steel. For the atomic energy community, we said there the integration was limited to atomic energy. There was no such limitation in the EEC. There is no such limitation in the EU today. However, most of the times, the international organizations or the area of international organizations is limited. For instance, the World Health Organization, it is limited. The World Trade Organization, it is limited. On the contrary, in the EU, the integration can apply to any area of economics. All right? Another characteristic is supranationality of certain EU institutions. In other words, some of the EU institutions have supranational characters. What do we mean here? Do we mean supranationality of the EU? No. Here we speak about something else. We will be speaking about supranationality of an EU institution. What do you think? Which institutions of the EU might be considered as supranational? Yes, Deniz?
Court of Justice can be, because we said that they interpret the laws.
Yes, but here we will speak about supranationality of political institutions of the EU. Of course, the European Court of Justice is above all the institutions, national or European, to interpret the law, for example. Yes?
The parliament mainly, because a lot of people from different nationalities come together to make decisions about all of the people who are in the EU, so it's supranational in that side.
How about, is the council also supranational then, in terms of the nationality of the people?
I wasn't trying to say that. I was trying to say that, like, when they, okay.
Because, because yes, in the parliament there are people, the representatives, coming from 28 member states. Is that true? Yes. But in the Council of Ministers as well, there are 28 ministers coming from 28 member states. So there should be something else for the European Parliament. It is true. It is one of the supranational institutions of the EU, But why is it so? And it is linked to nationality of the representatives as well. Umut?
They are not representing the goods of their own nationality, but for the sake of EU.
Exactly. Yes, it is true. The members of the European Parliament are nationals of the member states. However, they do not represent the national interests. Instead, they represent...
European?
No. They represent the interests of the individuals. This makes the European Parliament supranational. Although its members have or are the nationals of the member states, once they come to the European Parliament, they forget about the national interest and they only think about the interests of the individuals. It is the European Parliament, as you know. It is the institution that represents democracy, democratic legitimacy in the European Union. All right? What else? Yes?
Commission.
The Commission is also supranational. Why?
It's about the interests of the EU, not their national interests.
Exactly. The Commission, as you will be seeing, the European Commission is the executive organ of the European Union. Executive in Turkish, yürütme. However, the Commission is composed of nationals from the member states, the commissioners coming from 28 member states. However, once they are approved as the European Commission, they forget about their national interests and only think about the interests of the European integration as the executive organ of the European Union. All right? Therefore, when we say certain institutions of the EU are supranational, we mean the European Parliament and the European Commission because of their compositions. All right? Although they are composed of the nationals, the citizens of the member states, these members forget about their national interests and rather represent the interests of the EU or the individuals. Any questions? Okay. Umut?
Can we say that Council of Ministers is also supranational?
Okay, this is my question to you. Can we say that the Council of Ministers is also supranational? Is it yes or no? Yes?
I think it is no.
It is a no.
Council of Ministers are ministers from coming their state, and they represent their state's interest, not the common interest of EU countries, but only their states.
Okay. Yes?
I think it's not just interest, because I think when a minister comes to Council of Ministers in EU, I think the main goal is to accreditate the national legislation with EU legislation. So they're acting for their national law, to accreditate their national law with European law, like ministers. If you take a decision in the Council of Ministers,
okay.
For instance, Minister of Economy of France is trying to establish a new order in France in order to accreditate with EU. So the main goal is for France itself, but not for EU.
This would mean she represents the national interest. It is rather the contrary. It is rather the contrary. When a national representative comes to the Council of Ministers, she would defend her national policy there. She would not do anything which would be in conflict with the national interest, with the national policies of that member state.
So we can say the interest automatically.
Yes, and once a binding document is adopted by the European Union as such, then that French minister, for example, has to go back to France and change the national legislation which is in conflict with EU legislation.
That's what I mean, actually.
Yes. But in the Council of Ministers itself, they can't do anything which is in conflict with their national interests or national policies, okay? Umut does not accept this answer. Umut doesn't accept that council is not supranational.
I think the structure of the council is almost the same with other IOs, but the voting method.
IO is international organization. Mm-hmm.
And but its voting method is decisive, I think.
Exactly.
It is determinative of EU being supranational. So, and it is applied in the Council of Ministers. It is important, I think.
Bravo, yes. As far as the composition of the Council is concerned, is Council international or supranational when you compare it with the European Parliament and European Commission? Yes, as far as composition is concerned. As far as the structure of the Council is concerned. What do you say? We just said it is international. Why? Because the ministers come to the council brings the ministers together, and of course the ministers would defend their national policies. This is normal. Therefore, as such, the Council of Ministers acts as like an international organization, or it is composed as an international organization. But qualified majority voting is the main voting method of the Council. Do you remember we said qualified majority voting makes the EU more supranational? Yes, there is a link between the use of qualified majority voting and supranationality. A member state which has negatively voted on a proposal has to implement that instrument even if it is contrary to its national policies. Therefore, there is a direct link between supranationality and qualified majority voting. And qualified majority voting is the voting method of the Council of Ministers. It is the Council that uses qualified majority voting. Therefore, yes, although its composition is international, the Council's composition structure is international, the use of qualified majority voting makes the Council more supranational as an EU institution. Do you see the difference between the European Parliament or European Commissions being supranational and the Councils being supranational? Do you see the difference? There is a difference between them. Why do we call Parliament and Commission as two supranational institutions of the EU? Why do we call?
Because of the interests. Because
of their composition and because of the interests they represent. How about the Council?
Only the voting procedure.
Exactly. The composition makes it international for sure, but its voting method, the more the Council acts with qualified majority voting, the more it becomes a supranational institution. All right?
But we cannot say that the Council is supranational.
No. When you say the Council of Ministers is a supranational institution, then this would not be a whole through sentence. You have to explain yourself, okay? All right. Anything else? Yes, Atakan.
Question, but it's not about this principle, the previous one.
Which one?
The one before this, about things that EU can make laws about.
Okay.
It said that in, for example, World Health Organization, they can only make laws about health. And in EU, we said that there is no limit.
No, we said the area of competence of, for example, World Health Organization is limited to health issues. Whereas in the European Union law, there is no such restriction as a principle.
Yes.
as provided in the founding treaties, yes.
But I guess you said later that it's
limited.
Yes.
I know.
And only in economics.
Okay. This is what, okay, when we say the transfer of power in the EU from the member states to the European Union itself is in huge areas. We don't mean that the EU can legislate in any area it wants. When we say there is this large the transfer of power in many areas, in wide areas, we say it when we compare the EU with international organizations. Therefore, when you compare the EU with other international organizations, you say, there is such great transfer of power in the European Union. But this does not mean that legally the EU can act in any area. It is on the contrary. One of the main principles in EU law that we will be dealing with is the principle of limited powers. We will be talking about that very often. In Turkish, sınırlı yetki prensibi, Avrupa Birliği hukukunda sınırlı yetki prensibi. This is a principle clearly provided in the founding treaties. It means the EU institutions can only legislate in those areas provided by the founding treaties. They have to act within the limits of the powers given to them by the founding treaties. So it is not like the EU can legislate in every area it wants. It is the contrary. Its power is limited with the founding treaties. We will be seeing later that for the policies that the EU has competence to legislate, you will see that the treaty provision, the provision of the founding treaty, clearly provides, for example, which institution shall act. Shall the Parliament and the Council act together? Is it the ordinary legislative procedure? Is it the consultation procedure? Is it another special procedure? How will the Council act? Will the Council act with qualified majority voting? Will the Parliament act with simple majority, etc.? Therefore, all the details are written in the founding treaties for every policy where the EU has the power to legislate. Therefore, it is not 100% true that the EU has power in every area. It is the contrary, as we will be seeing when we speak about the competences of the European Union. Okay? The next topic will be two important concepts of EU law. We are still in the introductory part of the course. We will be dealing with two important policies as widening and deepening in the EU. Widening in Turkish, genişleme, deepening, derinleşme. Widening in English means enlargement, enlargement. How would you define enlargement or widening?
For EU?
Yes.
Getting more members.
How would you define it in a more technical way?
Admission of new members.
How do you say?
Admission of the new members.
That wouldn't be very technical. And it's accession. Accession of new member states to the European Union. Enlargement is one of the very important policies of the EU. Then what is deepening? The EU widens and the EU deepens. Yes, Umut?
EU practicing more areas.
This is one important thing. The EU will have a say in more areas, in more policies. That is true. Yes, Deniz?
I mean, putting limits on membership, for example.
How?
I mean, the countries who have rule of law, who respect human rights can be members, for example. Because they can't accept every country, whichever is
then this wouldn't be this about enlargement, widening?
It's about deepening.
Why deepening?
Because they put limits, I mean, they regulate about membership.
Then no, it won't be specific to membership. The EU then can, the more it regulates, this would be included in deepening. That is true. Yes?
Can it be having more executive powers? Or
Yes. It can be having any more powers in any area. Deepening means the change or changing and developing the policies as well as the structure of the European Union. As you will be seeing, widening happens with accession treaties. Accession treaties. We said that widening means enlargement, and enlargement takes place with accession treaties. Accession treaties in Turkish, katılım antlaşması. These are agreements. We will be dealing with them very short when we speak about sources of European Union law. And you will be seeing that these are the treaties between the EU member states and third countries who would like to join to the European Union. Therefore, the widening or enlargement takes place with accession treaties. How about deepening? In deepening, you change the structure of the European Union. You change the policies. You add more policy areas. You may change the voting procedure in the Council. You may change the composition of the Commission. You may change the jurisdiction of the Court of Justice. You may add more policy areas to the existing ones. Therefore, what do we need as a legal instrument? Yes, Atakan?
Legislation.
What type of legislation would this be?
Structure.
What would be the technical name for that, Umut? Bravo. Amending treaties. Amending treaties. In Turkish? Sorry? Amending treaty? What is it in English, amending treaty? What do we mean with that?
Addition to amendments.
Sorry? The treaty making amendments. Ah, bravo. Yes. Making amendments on what? On founding treaties. Therefore, amending treaties are sources that amend the founding treaties of the European Union. As you will be seeing, accession treaties and amending treaties are primary sources of EU law. Primary source? Primary? Birincil. Primary sources of EU law, like the founding treaties of the EU. In the second hour, I will be starting with widening. All right? Okay, 10 minutes break. Tadil Anlaşması. Avrupa Birliği'nin kurucu antlaşmalarında değişiklik getiren anlaşma. Tadil Antlaşması.